But I'd also like to discuss the discovery motion prior to beginning the full hearing.
Okay, I mean, you had kind of indicated that, certainly, you know, that's what I indicated to the commission members we would immediately be talking about, but you had also indicated that, you know, you were willing to move away from that and proceed to the hearing, so whatever you want to do is fine.
Okay, and I want to get, you want me to talk from here or stand up?
I think it's probably better, I would guess it's probably better if you stood, but that's the commission's choice and not mine.
I think, yeah, I think.
You want to have a vote with it?
No, I just want to know what everyone feels comfortable
Make a
with.
motion, not these things.
No, I just want to know what everyone feels comfortable with.
It doesn't matter to me.
So just, what I had indicated to the executive director is my willingness to drop the discovery motion, but I did not say that I was dropping the discovery motion. I'm still prepared to drop the discovery motion, but I need to have some clarity in so doing. Let's keep in mind here that this matter was referred to a full hearing, I think, over 20 months ago. Over 20 months ago, it was referred to a full hearing. There's been some people who've been involved in longer hearings before. A lot of you haven't, because it's so long has gone by to when this was held over for a full hearing. I think the key thing involved here is whether or not, for certain, on the record, Ms. Schmidt is asserting her right against self-incrimination when it comes to all these things: testimony, interrogatories, depositions, document discovery, and filing an answer. Okay? If she is asserting her right against self-incrimination, as has been indicated to me by counsel, then I would like to know that on the record before making a decision to drop the discovery motion.
Mr. O'Brien,
Well, I guess I'm not sure he's entitled to that to a particular point in time, Madam Chairman. Either he has a motion to compel discovery, which he did file and I did respond to, and if he's going to go forward with that, I'm prepared to address that. But I noticed just before I came in the hearing room that he posted on his Facebook page that people should tune into this hearing to see Jean Schmidt assert the Fifth Amendment. And she has not done that yet. She has not made a decision yet. And until there's a point in this hearing where she's required to make that decision, I don't think that he can ask her to make a decision. She's here today, and we'll make a decision on presenting. Certainly, I have 8 exhibits that I've marked and presented to you, and we'll present information and evidence. But I think she wants to tell her side of the story when it is the right time to do so. So if Mr. Hicks wants to proceed with a motion to compel, then he certainly can do that.
I would just like to correct the record as to what was just said. What's on my Facebook page says this: 2 cases today, Schmidt and LaRose. Schmidt is claiming she will take the 5th. That is based on a letter, which I'm glad you could, I don't know that you could introduce an exhibit now, but it's one of the additional exhibits that's in that stack, from you, Mr. O'Brien. Okay, so that's a factually correct statement as to what was indicated to me in an email from you. So I don't like the mischaracterization of what I've said or what I have done. That being said, I think you are a prosecutor. Okay, this is a civil procedure. We're under civil rules. So somebody taking the 5th in a civil procedure, actually it does imply that a criminal activity took place. Unlike in a criminal matter, this is a civil matter. I think, given the nature of this commission and the civil rules, leaving it kind of a mystery as to whether the candidate is asserting the 5th or not is not appropriate due process for a civil matter. Okay? If she wants to take the stand then, and then refuse to answer certain questions, she can do that. But the point being, right now, as we stand right now, in the letter that's been provided by Mr. O'Brien to me, she asserted that she did not file an answer because of the fear of incrimination, that she will not submit to, that her treasurer will not submit to deposition for fear of incrimination, that she will not answer interrogatories due to fear of due to that needing to take a fifth, that she will not submit the document discovery. Those of you around, even Alan Freeman submitted the document discovery without a hassle.
Well, we'll stick to this though.
And she will not testify asserting her right to self-incrimination. That's based on the letter you sent me yesterday. So I think as the complainant, clarity as to, is she on those matters? So for example, on this motion to compel, are you asserting the right of self-incrimination as a reason she will not respond to document discovery? That's a very legitimate question, specifically related to this discovery motion.
Okay. Mr. O'Brien.
Yes, Madam Chairman, I believe it was in August of 2021, I filed a document with this commission expressing our viewpoint, which frankly was sanctioned in the Freeman case. And again, I know that this is a separate case, but the same kind of issue arose in that case. And I have been very careful not to use the word the Fifth Amendment, because Mr. Hicks wants to bandy it about that Representative Schmidt is asserting the Fifth Amendment. The Commission's own rules say that a respondent can't be compelled to testify, and I think that was the ruling of the Commission back on the Freeman case. And as Mr. Hicks well knows, the referral can be made by this Commission, although it's rare for a criminal prosecution. So we're just Mr. Hicks, in June of 2020, I believe, or 2021, filed a complaint alleging she violated 4 Ohio statutes on campaign finance filings. He didn't file against the treasurer, I might add. He didn't file against the campaign committee. He filed against her, Representative Jean Schmidt. He later filed an amended complaint and didn't file it against the campaign committee or the treasurer. The commission had a preliminary review, and Mr. Richter recommended this complaint is deficient on its face. It should be.
I want to object to this as the relevance to the discovery motion. He's sort of making a case in addressing the complaint when the issue before the commission right now is a pending discovery motion.
At least if I could finish without interruption, and at least I normally, if I have an objection to what the other counsel is saying, I might object and not give speech. But in any event,
So I object.
Continue.
Okay, thank you. I guess I was just trying to give the history. The commission voted 3-3 to not follow the recommendation of Mr. Richter. And as I recollect, part of the concern was that perhaps there might be new information that could become available if it's set for a hearing that would justify having a hearing. And some of the members, including I think Commission Member Tavares and I think Mr. Norman at the time, said, well, is this done and over if we decide today to dismiss it, or if new information comes forward in the interim, could we refile it? And I think my take that was the reason for setting it over for a hearing. And Ms. Tavares did make that motion and set it over for a hearing. As Mr. Hicks said, it's been pending for this amount of time. At least, it's my view. He has a motion to compel. If he wants to go forward with it, he can. He said, I thought that he was prepared to go forward today. He did not say that he intended specifically to withdraw his motion to compel discovery, but he said he might. So I guess it was his motion. He can choose to withdraw it, or he can choose to argue it to the commission, and Mr. Richter can make a recommendation. The commission can vote on whether the motion to compel the discovery should be required.
Thank you.
Well, the one comment I would make, Mr. Hicks, to realize that while this commission acts in an administrative capacity, the statutes that we are enforcing are potentially criminal statutes. As Mr. O'Brien referenced, and we could make a referral for prosecution. And so therefore, we have to respect any respondent's of willingness, ability, however they want to phrase it, in terms of not producing any information on their behalf, whether you want to call it taking the fifth or whatever. You know, and so this commission has long respected that set of circumstances, and that would be the case here. You know, Ms. Schmidt can't be compelled to testify against herself unless she chooses to do so on her own, and that's a decision that presumably she would make down the line somewhere if you put your case in today. And then after the assessment is made of what it is that you've established, whether she wants to testify or not, is a choice that she then has to make.
So I want to clean up just a few things that he said. The actual complaints in multiple places say Ms. Schmidt and/or Schmidt for Ohio. The specific allegations are against Ms. Schmidt and/or Schmidt for Ohio in the complaint. I would direct people to look at, in the packet I just handed out, page 25. So there's some things being said here. I also think, I don't know if anybody here from the commission can remember what the votes were, but I don't remember this 3-3 vote. I remember what I thought was a unanimous vote to hold it over for a full hearing, and then you did a motion to reconsider, and that motion to reconsider, that decision failed by a unanimous vote. So the characterization that this was some hair-splitting thing that barely got held over for a full hearing, I think is incorrect to the record. And if there's a commission that can remember I don't remember the exact votes, but my recollection is unanimous vote for a full hearing and a unanimous vote against your motion to reconsider that I believe was adjudicated on September 8th of 2021. As it goes to discovery, the rules of the commission say prior to availing themselves of powers of the commission to compel discovery, a party shall reasonably submit to the request of another party and produce the necessary documents, information, and other discovery items without the intervention of the commission staff. That's Rule 3517-1-09. The Freeman thing was probably a wild ride in terms of, I don't know how often it's happened that somebody's tried to assert their right against self-incrimination in a civil procedure, but I'd like to remind people, if I admit to a crime in any civil procedure, I'm subject to criminal prosecution. So this is a very dangerous slope where you have especially people, again, think of that person running for township trustee that would never think of this elaborate claim, okay? Is that you have people that should know better that are saying, oh, well, I don't want to have to testify, I don't want to have to provide discovery, etc. So those are your own rules. And at the time, with the Alan Freeman matter, what he ultimately testified, okay? But he had filed a response affidavit. He also provided document discovery. And I don't know that this commission has ever had a legal opinion on document discovery. Can a party refuse to provide document discovery before the Ohio Election Commission? Some of you are new here, and I think these are very dangerous grounds where sophisticated politicos are now using these assertions to basically come stonewall before the commission. And I think in a civil procedure, on the motion to discovery, and my inclination to drop that motion to discovery, I don't think it's unreasonable that I know whether the party is asserting privilege, I'm sorry, not privilege, but the right of self-incrimination on every aspect of discovery, including document discovery.
Thank you.
Madam Chair, I ask a question to the director. So, I mean, there's a lot of stuff being said, and I'm only a year in, and I'm not an attorney. So, is it true that it is the position historically of the commission that, without making any specific claim, that a, respondent can just say no to discovery? Because the way I'm hearing it is basically there's no discovery unless the respondent just doesn't know that's an option, right? I mean, there's really no discovery in our process at all, ever, based on what I'm kind of hearing. Is that true? all that the respondent could do is say, well, I'm invoking the potential right, there could be some sort of criminal prosecution, therefore I'm going to do anything. That seems to be, no discovery at all, ever.
Well, as
the whole.
in directly requesting it from the respondent, yes. You can still do discovery. You can reach out to whatever other sources may be available to you. But this commission has, actually over the first few years of the commission, the commission wasn't exactly the best at, let's say, respecting a person's potential use of the Fifth Amendment rights. But after, shall I say, getting a little bit more information on it and looking at the circumstances a little more seriously, the commission subsequently, realized that while we are acting in an administrative capacity, and technically all these folks could come back and say, that we dealt with today with the campaign finance filings, I'm not going to respond to you, then they're subjecting themselves to the fact that we have no response from them. We don't know what their circumstance was. We have an ability to take the word of the Board of Elections and proceed, and they don't have to respond to us. That is
Even in a hearing.
Huh?
Even in a formal hearing.
Regardless of whether it's at the preliminary review stage or hearing or whatever. That's from the respondent. Alternatively, others, you could reach out to other sources. You could, Mr. Hicks could bring in witnesses. He could reach out to anybody else that may have pertinent information. To a degree, no different than we saw in the Rose case today, where folks did submit responses to the commission. Historically, the commission's looked at if we get good information on a matter, then we can rely on that information to proceed. I think as we did in the Rose matter today. But this commission has respected the fact over the last probably 20 years that we cannot compel a respondent to do anything against their interests because of the possibility of referral for prosecution.
But they don't have to claim that, so the bottom line is, we just don't compel discovery. They don't have to give a formal reason.
Correct.
We're assuming that reason could be criminal prosecution.
Correct.
That's not a requirement. So the bottom line is that the Ohio Elections Commission position is, we do not compel discovery.
We do not compel discovery from the respondent, from whoever is listed as a respondent.
Okay, I just want to make sure I understand. Okay.
No, I understand. It's a reasonable question. And I don't know if I want to say it's a slippery slope, but, and is it likely that this case is going to be referred to prosecution? That'll be determined by, whenever this goes to trial and what the result is. But there's always that possibility, and as long as there is that possibility, we have to respect a respondent's desire not to produce any evidence that they don't have to produce because it could put them at risk.
Thank you.
Sure.
Mr. Hicks?
So I just want to clean up a few things that were said by Mr. Richter. First, your rules for discovery are specifically related to parties. Okay, so if I go try to get discovery from a non-party, they can tell me they're not going to give me discovery. And that's happened. It happened in the Alan Freeman matter. But your rule 3517-1-09 on discovery, it's in your own rules, it specifically refers to request of another party to produce the discovery between the parties, okay? I want to point out also that your rule 3517-1-04 about service and filing of pleadings and documents, okay? And I'll read, this has to do with the shall file a response, so that somebody who's a respondent, per your rules, shall file a response in the form of an affidavit, okay? So that's one of your things. Which, by the way, if these things are all up in the air, somebody should be doing a lot of emergency rule changes to the Ohio Administrative Code, because what we're hearing here today is that the rules in the Ohio Administrative Code, as they stand today, are not enforceable by this commission. They're not going to be enforced. The rule that I mentioned, the 3517, I'll come back to 04, 3517-1-09, specifically as if such efforts fail, an aggrieved party may petition the commission to compel the necessary discovery. If those rules aren't valid, and they've always not been valid, then why are they in the Ohio Administrative Code? It should say in there, no party shall be required to submit the discovery, and the commission shall do nothing to motivate discovery. I want to remind you that this is supposed to be a civil process, subject to the civil rules, particularly Rule 26 and Rule 30. And again, legally, I'm not a lawyer, okay? But if you go read the case law around this, is when somebody asserts their right of self-incrimination in a civil matter, that is an implication that there were criminal activity. But I want to go back to 3517-1-04, your rules. This is the one that has to do with filing a response on the merits in the form of an affidavit, okay? Shall, and with a shall, when the word shall was the word before it here, that must. It says, the last paragraph of section A of response of that rule, if the respondent fails to find a proper response, which by the way is in the form of an affidavit, commission staff shall timely notify the respondent by regular mail that by failing to respond or show good cause for such failure to respond, the respondent may be deemed to have admitted the allegations in the complaint and may allow the commission to make a finding against the respondent. Again, based on what Mr. Ricker says, especially since, at least from my experience, the Freeman matter where this stuff all came into full focus, why are these rules still the same then? It's almost 2 years later. And that's, so it's a long time after. Why have the rules then not been changed to reflect the things that are being said by the executive director? And how is a complainant supposed to come forward and find out in hearings that, hey, the rules that are actually in the Ohio Administrative Code and that say civil procedure, there's a whole litany, but 26, there's a whole, in 3517-1-09, there's a whole list of what rules of civil procedure apply to these hearings. If those don't apply, and Mr. Ricker, if your assertion is those don't really apply, why hasn't there been any action to fix them in 2 years? So I think that as a complainant in what's supposed to be a civil process, who is supposed to have the ability under Rule 26, under Rule 30, under discovery rules to do things on my part, you put this situation into me where it becomes, what is the point of this whole commission? If people just waltz in and say, hey, I don't want to respond. So I just wanted to correct a few things because you made a statement about you could go do discovery from other people. That's not what your rules talk about. They talk specifically about discovery between the parties. And I wanted to hit on, if these rules all aren't valid, how am I supposed to put forward a case? How would you have felt about that, Mr. O'Brien, if when you were a prosecutor, the documented rules do or don't apply based on particular situations? So again, I come back to, I think I have the reasonable right as a complainant to know whether on, and we could put it in the context of this motion hearing, in this motion discussion, or whatever it is are you asserting that you are not going to respond to any element of discovery, which I rattled off a list of things from the standpoint of filing a response, depositions, document discoveries, interrogatories. Let's stop there. I won't go to testimony here. I'll stop right there. Are you asserting that even if this commission were to compel discovery, you are going to assert your right against self-incrimination and refuse discovery? Because that's very important to me in terms of proceeding today or not with this case.
That's fine, but you should be addressing us, not Mr. O'Brien, so please make sure, you know.
I apologize.
Thank you. Should I respond?
Madam Chair, the respondent did file an affidavit in response to the complaint. It's Exhibit 4 in the documents that I gave to you. It's included with a motion to dismiss. It's a affidavit from Rob Soooo, who was the executive director of the Republican Party, who said in that affidavit he had now assigned Mr. Mancini to work on the Schmidt campaign, which were two of the allegations that had been made. Criminal offenses, I might add, that Mr. Hicks has made, and at least when affidavits claiming crime has been committed, be it in the municipal court or pursuant to an indictment, the person that files it has a burden of proof, as does Mr. Hicks in this hearing today. And if he's not prepared to prove the allegations, then Mr. Richter's recommendation from August of 21 should be followed. And if he is prepared to prove the allegations, then he has to honor whatever the law may be in the area, and that is he can't compel discovery from respondents, which Mr. Richter has said twice here today. He said in the Freeman case that Mr. Hicks was also involved in. So at least, I don't know if the chair has the ability to call the question.
What's this exhibit you referred to, please?
It's exhibit 4 in the package I gave you this morning, Mr. Hicks. It's the affidavit of Mr. Seaclar from the Ohio Republican Party, which is exhibit 1 to exhibit 4 of that motion. It's filed with the commission August 11 of 21. Frankly, I think why there was a 3-3 vote, cleaning up the record, since you'd like to do that. There was a 3-3 vote on the motion Ms. Cunningham made to follow Mr. Richter's recommendation to dismiss the case that day. Subsequently, you're correct, that having tied 3-3, the matter was settled for a hearing unanimously, and a motion to be considered that was denied unanimously. But it's on YouTube, and I watched it yesterday. At minutes 45 to 57 of the commission's meeting, if there's a need to review it.
Thank you.
Do you remember what day the hearing was, the preliminary review was?
It's August 12th to 21.
This particular affidavit is not a response to the allegation, nor is it a response by anybody who's associated with their campaign. Okay, so it's the particular affidavit relates to the assignment of resources, not to her response to the particular complaint. So I just want to throw in here that to characterize it is that the respondent filed an answer in the form of an affidavit because Rob Soooo gave you an affidavit who has no connection with the Jean Schmidt campaign or Jean Schmidt at all, is disingenuous. There was never a response by a party in this matter. Other than, per se, per se there was some element of response in your motion to reconsider, per se, in the form of legal counsel, but that was not in the form of an affidavit. But I come back to my question again, are you, as it relates to the motion to compel discovery, I think I've heard Mr. Richter say that from now on the commission will never compel discovery. And I think I've heard you say that you would not stand for discovery on the grounds of self-incrimination. If that's the case, I would like to have that be clear on the record from both the commission and from Ms. Schmidt that that's your stance, because that would have a direct relation, because then it's effectively my motion to compel becomes moot. Because the commission is saying you would never, the executive director is representing that he would never grant the motion to compel going forward on discovery. And I think they're saying they wouldn't respond anyway if you did. And that's absolutely critical to my dropping or maintaining that motion.
Thank you. Mr. Anthony,
A couple at least. One, and we keep going back and forth through a variety of different things here, and just if you think back this morning to the Euclid Public Library case where the lady appeared before the commission, we have received a written response. She also showed up and made a comment to the commission. We regularly will have persons appear in person before the commission and make a statement to the commission, on which the commission then relies to make a finding in a particular case, even though we may not have received a written submission. And looking back at August 12th, with regard to whether a response was ever filed or not, when the commission held a preliminary review in that case, Mr. O'Brien was present on behalf of Ms. Schmidt. He offered comment on behalf of his client. So there was a response at that point, at that August 12th meeting. My recommendation would be to deny Mr. Mr. Hicks' motion. And then we can either proceed to hearing, or if he needs more time, we can set the matter to a later date. If he wants to do something else as it relates to trying to provide evidence to the commission. But my recommendation would be to deny the motion.
Questions from the commissioners? Comments from the commissioners?
Just for my clarity, exactly what is the motion that's for? That would be.
The motion to allow discovery, to allow further discovery, correct.
I guess the one comment or request, it might be worth considering an advisory opinion on clarifying, assuming that the executive director thinks that there may be there seems to be at a high level, I guess, without, just kind of hearing, there seems to be, certainly on my end, some confusion between, what the, Ohio, the OAC says and what our policies are. It would, maybe there's an advisory opinion opportunity, or maybe that's, I don't know, maybe it's something, but I certainly feel that I don't know where the OAC ends and historical commission precedent begins, and it makes it tough to come up with what I feel is a good vote one way or the other in this situation, frankly.
Okay, thank you. Any other comments? Can you tell me what, you've cited some different civil codes. Is there something that would help maybe Commissioner Knight with making a snapshot of what it is that we do, or that we, as opposed to what has traditionally been done?
We realize that the vast majority of cases that the commission deals with are referrals from the various county boards of elections. And in referring back to the rules that Mr. Hicks was referring to, I wanted to make it clear that a respondent is, I don't know if I want to say an ability to submit a response to the commission that gives an explanation of the circumstances, and if they don't, then the commission may use that as a basis to make a finding against them and impose what it believes the appropriate sanction. The majority of matters are dealt with that way. People submit a response, give us an explanation no different than the lady that had the two-page explanation with all the various maladies that her family faced, and you can take that into consideration. And if we don't get a response, if you'll hear me say, then I will reflect that in my recommendation to the commission as well, to, let's say, impose a more substantial penalty. Whether you want to go from 50 to 100 or 100 to 150 is substantial, most people consider that to be the case. So it impacts the recommendations that I'll make. But alternatively, you have a situation like this where you have something that becomes much more contentious, and someone wants to, someone, a respondent, looks at the situation and says, hey, I believe that I could potentially face more serious criminal prosecution than just an administrative setting. They want to protect that right and ability to.
We're not requiring them to say that. That's not required. The way it's been described, they don't have to say anything. They can just nod, and they cannot be compelled. This commission won't compel them because they might have that problem.
That's
So
correct.
it doesn't, so there's no there's no discovery, and the way Mr. Hicks has described the code is it seems to offer like the ability for a complainant to have some through some civil procedures that I'm not familiar with. But we have a default, our policy as described is we don't require them to say that. We just don't, they don't respond. We take that into account in our, evaluation and determination. But again, our default is to not require anything. We just take into account they didn't say.
Correct. And I think there you have the difference between, at least one thing I would comment on is a constitutional right that someone has under the Fifth Amendment.
But we're not requiring them to say that though, right? They don't have to say that. They don't have to say anything. They just don't. Like we're not requiring them to deny this discovery based on that.
That's
right?
correct.
They just don't have to do discovery.
That's correct.
But in a normal matter, they would have to claim, assert that privilege themselves.
Just said it seemed a little lopsided.
Well, we're here because this man chose to file a complaint alleging 4 crimes were committed, and for a year and a half we've been denying it. We denied it with the affidavit that we filed. Mr. Richter, looking at the complaint with 25 years experience down here, recommended it be dismissed. The commission tied on that vote, and then it was set over for this hearing today. We're here today, we're ready to proceed, and Mr. Hicks, whether we like it or not, under the law, and sometimes, as I frequently told people, it's the law, so we have to follow it, whether we like it or not, kind of situation. And we're here today prepared to proceed, and so advised Mr. Hicks and advised Mr. Richter earlier this week, or even several weeks ago. We're here, I might add also, because Mr. Hicks sued you all and said, give me a hearing. I don't know if you know that or not, but we're here because Mr. Richter said it for hearing, because there was a lawsuit filed by Mr. Hicks, which is still pending. So we're here, we're ready for the hearing. Ms. Schmidt is missing a legislative kind of thing to be here this morning because it's so important to her. She'd like to get it behind her, and at least answering, I think, the commission members' question. I don't believe, as I did on August 12th of 21, that Mr. Hicks has a case. And so I think I would like to see him present his case, and I'm going to ask the commission to dismiss it based on the evidence he has presented, because his evidence will not show a violation. And so at that point in time, if the commission would deny it, then Ms. Schmidt would have the opportunity to herself then testify and explain the circumstances, but it would be only at that point that she needs to make a decision. And while Mr. Hicks says that this is a civil administrative proceeding, that's correct, but your rules do contemplate conducting it as if it were a trial with opening statements, presentation of evidence, and those of you on the commission who have seen some of these hearings are well aware of that. So at least, I don't know if that clarifies anything better, from the respondent standpoint.
Thank you. Yes.
I just want to clarify that Ms. Schmidt is here because she was a teen householder candidate whose name stood up all over the place in other cases. So not because this thing you saw with LaRose, you see now, I'm the demon as a citizen, at no financial or other value to me bringing forward these kind of cases. I take umbrage to that. These constant personal smears of me, that somehow I'm the bad guy and I caused somebody to do something. I didn't cause Ms. Schmidt to get in bed with Larry Household.
Okay, no. We're gonna stick to just the facts on both sides. Commissioner Lyle.
Yes, Madam Chair. So I have a question for Mr. Richter. So is there a way, obviously we have a bullet bug here, without being able to seem to move forward. Is there, so we have the issue with the motion and stuff. Is there a way that we can ask them to, for lack of a better term, brief that issue and revisit it and then go forward with the hearing? Can we do that?
I'm not sure how we would ask them to do that and go forward with the hearing.
Can I just say something?
Well, we're prepared to go forward.
I'm
You know,
prepared to
she-
go
she- She will
forward.
testify, she will
Please,
waive any
let's
rights she
move
may have.
on.
She wants to get this done today, she's prepared to testify, she's prepared to explain her circumstances, and so at least Mr. Hicks can withdraw his
Present his
motion
case.
and present his case, and if she needs to testify after he presents his case, then she will. But we want to have a hearing today to get this concluded,
Thank you. Are
if that's
you,
acceptable.
are you willing to withdraw?
I'm willing to have you guys have a vote on my motion of discovery, but regardless of how you vote, I'm prepared to proceed with the hearing today. But I'd like it to be on the record whether this commission, it will ever exercise its authority to compel discovery or not.
Commissioners have further questions? Hearing none, do we have a motion to deny, as Mr. Richter recommended? I guess my take on this is if we can, someone can make the motion to deny, at least if we can vote yes, or that we can vote no, we will know, and it will either pass or not pass, and we can move forward. Is that really kind of our options?
That doesn't sound unreasonable.
At least we can move forward.
Doesn't the person who makes the motion have to vote yes?
That is a good question, but I've wondered that myself, and I do not know the answer.
I don't believe it's
Okay.
okay, so
Found it.
there, so.
And Madam Chair, just to move the question along, I'll make the motion.
Do you have a second?
The motion is to deny.
Deny the motion.
So we're denying discovery. That's the motion.
I'm putting it forth for the commission.
Do we have a second? I'll second the motion. We have a motion on the floor, it's been duly seconded. All in favor to deny the motion?
Do a roll call or just do a general?
Can you please state the full motion?
What we have pending before us
Just so we're very clear.
is just looking for the complainant's motion to compel discovery is the motion that is pending before us. And there is pending now a motion to deny that motion to compel discovery.
Mr. Richter, will you do a roll call vote?
Mr. Lyle,
No.
Ms. Hagan,
No.
Mr. Knight,
No.
Mr. Kolke. No. Mr. Stoutberg,
No.
Ms. Tavares,
No.
Chair Kaufman.
No.
The motion fails 7-0. So the motion is still out there.
Okay, so the next step, moving forward.
Hearing right now.
Please, with all due respect, I'm talking to our executive director.
Well, if it wanted to press discovery, we could presumably go to move to approve that motion. Or if Mr. Hicks decides he wants to withdraw it, we could proceed to the hearing but the motion is still out there. And it, you know, the motion to deny was denied.
So we have everyone here today. I believe at this point, we would all like to move forward. So if you would be willing to withdraw so we can move forward, or if not, then obviously it's going to be moved to another date.
I think you can move forward without taking action on a motion. Courts do it all the time.
Okay, then we will move forward.
Okay.
So at this time, yes,
Can we take a 5 or 10 minute recess because I'd like to get a bottle of water?
absolutely, yes. Thank you. So it's 12:05. If we could all take 10 minutes and be back at 12:15, we will recess at this time and be back at 12:15.
I have an off the record question. So what happens
Hold
if,
on, it's still running.
It's muted.
Okay.
what happens if, whether it's something like this or something similar?
Yes.
Yeah, that's just the, our video, I've got the
There's
audio
his-
here, so it's
He's
muted.
got a camera there as well.
Yes, he does.
Yeah,
There's a camera there
Yeah,
as
he's
well.
running the camera as well.
Oh,
I
gotcha.
would- I
That's
would-
good.
Oh, okay, fair enough.
Live stream on Facebook.
Yeah, well, you know, I prefer TikTok, I'm a big dancer.
Yeah, maybe that too.
Was permission to live stream requested from the chairman?
I don't know, I say that jokingly.
Yeah,
but-
Yeah, but in normal cases, you would have the discretion.
Is that live stream or is that just videotaping?
I think he's live stream.
Oh,
I don't know what he's doing. We would have to
If
ask
not,
him.
it will be.
Yeah, I didn't even realize that.
Previously, I think when we did speaking here, I could be wrong, but when we did Freeman, I think he was just videotaping. I don't think he was live streaming at that point, but it's possible. We never know.
Something to discover it on.
It's just part of the case.
I would-
Whether it would make a party violation or what. Case.
Miss Ophelia hanging in there?
She's done well.
No, I was
She
just
has
gonna
more
say, I
patience
didn't
than
notice it
anyone.
until a couple of minutes ago, I saw you rocking
No,
the
but I
little
think when
one.
we get something.
She's got more
I'll go
patience
find
than
out.
just.
Oh, that's, I was just gonna say, I would never try that with my water, I'm still telling you the truth.
I've got a little experience with the little ones being in tow. They usually do better in meetings than most adults.
Amen.
But
Oh, yeah, how many you got now, 3 or?
she's number 4, so we got a bonus. We had twins last round, so I don't think, we weren't together in my last term, right? Did we go out of term before me? Yeah, that's okay, yeah, the boys were born that round, so you didn't have to deal with the twin shenanigans, but they were just there the last 3 months of my last term, so just trying to fight veto overrides and whatnot.
I miss it, no, I don't.
Well, and we thought we had it bad, right? I mean, back then with the deficit being so significant,
Yeah.
now it's like you look at all the cultural decay, like, oh my goodness, it's just a train wreck all the time. And then they had, a cycle or 2 ago, you know, the attacks on the State House and just the craziness with the protests downtown and, you know, the Black Lives Matter stuff, it just got crazy, so. Each term has its own challenges, and now there's so much disunity that they're never gonna get anything done.
Yeah, I just saw Peterson in the tunnel down there. I hadn't seen him in years.
Yeah, he's always such a happy guy too, and he's
Excuse
probably
me.
just shaking his head. It's a shame when you've got the Republican trifecta.
It's good that he's back to the dark side though, back on the House side. 'Cause that's where he started.
Is he back in the House? I thought he was in the Senate still.
No, I think he's
Is
back.
Bob in the House? Okay, okay. I don't know why I thought he was in the Senate still.
Excuse me? You need anything?
You know, I am okay. I'm just rearranging
Okay.
pickup and drop off and
Understood.
piano lessons and it
Understood.
doesn't look like I'll be making those.
Have you been through a hearing before?
Oh, yeah, yeah.
How long do they tend to last?
It depends on the conjecture, the personalities, the facts, but, we had the Blackstone case in front of us, so that was several hearings and pretty drawn out days.
So this could be continued to another hearing?
Possibly, yeah, possibly, but, you know, I've not been in front of this particular case. It looks like the last time I heard it was in 21. Oh, absolutely.
I saw the
Representative,
video.
yeah, she's sleeping, she's almost, her name is Ophelia, she's almost 2 months. And I don't know, we never served together, but you served before and then after, obviously, but I served in the legislature from 2011 to 18. I actually served with Peter Stauber, who's an alternate today. He just came on today and I said, you must be having flashbacks because my first daughter was born when we were in the legislature and then my twins. And
You have twins?
Yes, twin boys, so that's why
Fraternal or
she's easy.
identical?
Fraternal, yeah.
Do they look alike?
They are, well, it depends on if they're both trim. One is heavier and taller and the other is shorter and smaller. But when one plumps up and one slims down, they look more similar.
Because I have a twin sister
Oh,
and we
are you
look like,
fraternal or?
we are technically fraternal, but
Okay.
we look identical.
And there are the twin